This really is a flagship event here at the law school. It's always greatly anticipated, and that's certainly true of this year's lecture and this year's lecturer. The lecture series was inaugurated by Supreme Court Justice Hugo Black in 1960. And since then, it has each year provided a forum for our community to hear the nation's leading jurists address both timely and enduring questions about the rule of law and its role in our society, in particular focusing on questions of constitutional law. Our professor Norman Dorsey has directed the Madison Lecture Series since 1977, and typically it would be Norman before you this evening welcoming you and introducing the lecturer. Norman's unable to join us this evening as he's unwell, but he does send his greetings and his regrets. And let me say a word about him. Norman is our longest serving faculty member. And in addition to directing the Madison Lecture Series for many years, he is the Stokes Professor of Law, the co-director of the Arthur Garfield Hayes Civil Liberties Program, and at least until the completion of John Sexton's tenure as president, a counselor to the president of NYU. John says that when he was dean here, Norman's official title was that of Uber Dean, and I think he retains that now as well. His longtime leadership at this lecture series is just really one of many ways that Norman has contributed to the life of the law school, to the law, and to society. As I'm sure many of you know, Norman's work defending civil liberties has had a profound influence on this school, on legal education, and indeed on this country. He has taught and mentored countless students, and his vision for this law school really has been instrumental in transforming it into the institution that it is today. And Norman is a deeply beloved member of our community. We wish him a speedy recovery. Now, the Madison Lecture is a wonderful tradition in part because it's an opportunity for us to welcome members of the judiciary, not only the lecturer each year, but those who come to hear the lecture. And we're really thrilled that this evening we have Judge Pierre Laval of the Second Circuit. Where is Judge Laval? There he is. Who himself delivered the Madison Lecture in 2005, and also Judge Beverly Martin of the 11th Circuit, on the circuit on which Judge Barquette formerly sat. And this year we are just thrilled to have the Honorable Rosemary Barquette, now a judge on the Iran-United States Claims Tribunal in The Hague, to present the 47th James Madison Lecture. Judge Barquette has had an illustrious career, to put it mildly. Prior to joining the tribunal, as I've said, she served for 2 decades as a judge on the United States Court of Appeals for the 11th Circuit. But her judicial career began earlier than that, in 1979, when she was appointed first as a state trial court judge in Florida. Then in 1984, she was appointed to serve as a state appellate court judge. And then after that, to serve on the Florida Supreme Court as the first woman justice in that court's history, and then as the first woman Chief Justice in that court's history. The title of her lecture this evening is Bringing Human Rights Home, ? I thought they were already here. Norman, when I was chatting with him yesterday, said that were he the one giving these remarks, he would note, hopefully, that there seemed to be a kind of principles of Christian charity found within this title. And Norman Dorsey wanted it known that he was pleased to find those notes and would look forward eagerly to not only Judge but former nun Barquette address these topics. Judge Barquette has lectured really around the world on a dizzying array of topics in places including Kuwait, Dubai, Qatar, Syria, Turkey, Algeria, China, Haiti, and Kyrgyzstan, to name just a few. She serves on the board of the ABA's Rule of Law Initiative and chairs its Committee on the Middle East and North Africa. She has been widely recognized for her many, many contributions to improving justice. She's received dozens of honors and awards from national and state professional, civic, and charitable groups, as well as 7 honorary degrees from institutions of higher learning. And in 2008, she was named a legal legend by Florida's 11th Judicial Circuit Historical Society, We are very, very pleased to have this living legend here with us this evening. Join me in welcoming Judge Marquette.
Thank you very much. God, I should be dead, I think. I thank you very much for the introduction, and I thank you very much for the invitation. Thank you. To participate in the conversation that has occurred over the last 47 years. I've had 54. We need to fix that now. My present law clerk, Ellen Gilly, is here, who suffered through 100,000 versions of this speech, and I want to acknowledge all of her very wonderful help. I will say it was a very big challenge to decide what to add to what has already been said about our Constitution by the members of the judiciary that have preceded me at this podium, very illustrative members like Pierre Laval. But so I was trying to search for something to say about our Constitution that perhaps might not have been said yet. And living in The Hague, where discussion about human rights in the world is ubiquitous, I began thinking about the protection of human rights and comparing our constitutional jurisprudence to the decisions of international judicial bodies. It seemed a particularly apt topic of conversation because many American international human rights scholars are urging that we bring human rights home. But it made me wonder what exactly that meant when we at home, at least in my generation, always believed that our constitutional rights have always protected our human rights to liberty and to equality. In fact, US lawmakers, senators have constantly and frequently expressed the view that Americans don't need human rights treaties because the Constitution covers all of our basic human rights. Now, to be sure, our country was established on the basis of the first quintessential human rights document, our Declaration of Independence. We founded our country on the self-evident proposition that all men are created equal and that they are all endowed with certain unalienable rights, among which are life, liberty, and the pursuit of happiness. We have prided ourselves on being the very first nation to assert in writing that the purpose of our government was to protect and secure these rights. This was the basis upon which our Constitution was presented to the people for ratification. James Madison, for example, writing in support of the adoption of the Constitution, proclaimed that the very purpose of government was the achievement of justice. And although we were the first to articulate this radical proposition that governments are obliged to protect the individual rights of freedom, equality, and justice, the proposition has now been recognized by countries all over the world, as well as in international agreements between countries. Today, all members of the United Nations, 193 countries, have ratified at least one of the principal human rights treaties, and over 30 have expressly affirmed their commitment to the Universal Declaration of Human Rights in their own constitutions. Yet, despite this uniformity in recognizing the obligations to safeguard human rights, the protection of these rights differs around the globe. Today, I would like to focus on one example of such a difference, and that is the treatment of gender violence and domestic abuse and the state's obligation to protect women and children from that abuse. This is one area in which our constitutional jurisprudence, despite its early promise and rhetorical commitment to human rights, has fallen far shorter in assuring their protection than have international and foreign courts with a much newer history than ours. The contrast between the international analysis and our domestic jurisprudence in this area is pretty stark. Whereas international bodies view a government's failure to protect women and children from domestic violence as discrimination and a violation of the right to life, liberty, and equality, our case law holds that the state is under no obligation to protect women and children from third-party violence. And this is something that I think a lot of people don't realize, that we have said in our jurisprudential cases that the state is under no obligation to protect women and children from third-party violence. Thus, we not only need to bring human rights home, but we need to bring human rights into the home. That we in the United States have a history of arbitrarily failing to adequately respond to victims of gender violence, whether in a domestic setting or outside of it, has been continually documented. We know that as a class, women victims of violence are afforded substantially lesser protections of the law than victims of other crimes. This arbitrary disparity of treatment is most pronounced in cases of domestic abuse, where government actors, even with actual knowledge of a specific risk, overlook or ignore crimes of violence simply because the victim was related to or in a relationship with the perpetrator. Now, international and foreign courts addressing domestic violence have considered and weighed the nature, the breadth, and the history of domestic violence, and based thereupon have recognized that a government's failure to protect women and children from domestic violence constitutes a violation of equality principles as well as a violation of other human rights, and that this violation requires a remedy. In contrast, our Supreme Court has failed to consider and weigh any of those factors, essentially dismissing them as irrelevant in its cases involving domestic abuse, thus holding that the state has no duty to protect women and children from third-party violence. Now, I suggest that this failure ensures much more than a simple vestige of the historically sanctioned domestic chastisement laws of the last century. Our case law has, in fact, continued into the present the history of legally denying protection to women and children. And on another related front, even if this discrimination were recognized as a constitutional violation, our case law would provide little chance of a remedy. Monell versus Department of Social Services and its progeny, along with the broad application of qualified immunity, insulate government actors and municipalities from liability, preventing the imposition of any meaningful damages or any sanction at all. The case of Jessica Lenahan, also known as Jessica Gonzalez, is a perfect example. Both the Supreme Court of the United States and the Inter-American Commission on Human Rights addressed her identical claim that a city is liable for the violation of human and constitutional rights when its police officers refuse to investigate or enforce a restraining order, which for Jessica Lenahan resulted in the murder of her 3 children. Jessica Lenahan had obtained a permanent restraining order from the Colorado District Court against her spouse, Simon Gonzalez, when the court found that irreparable injury and physical and emotional harm would result absent such an order. Jessica called the Castle Rock Police Department on at least 4 separate occasions to report serious violations of her restraining order. And notwithstanding Colorado's mandatory arrest law for a violation of a restraining order and the identical mandate written on the order itself, the police did nothing. One afternoon after these complaints, Simon Gonzalez abducted his 3 daughters, Leslie, 7, Catherine, 6, and Rebecca, 10. Jessica Lenahan called the Castle Rock Police Department to report the children missing, continued to call throughout the evening, and at one point showed the police the restraining order. The police did not make any attempt to find Simon Gonzalez or to arrest him. At approximately 3:20 a.m. the following morning, Mr. Gonzalez drove to the Castle Rock Police Station and began shooting at the station. The police returned fire, and they killed Mr. Gonzalez and thereafter discovered the murdered bodies of Leslie, Catherine, and Rebecca in his truck. Jessica Lenahan sued the city of Castle Rock under 42 U.S.C. Section 1983 for violating her 14th Amendment right by failing to protect her from a known threat of domestic violence. Now, due to the Supreme Court's earlier majority decision in a case called DeShaney versus Winnebago County Department of Social Services, Jessica Lenahan was foreclosed from arguing that Castle Rock violated her substantive due process right to life and liberty. DeShaney also involved a case of domestic abuse. The Wisconsin Department of Social Services, created to respond to and investigate complaints of child abuse, had received many reports of severe beatings continually being inflicted on 4-year-old Joshua DeShaney by his father. Though the abuse was chronicled by a series of first-hand accounts by the visiting DSS social worker, the social worker did not intervene and the department did nothing. Well, they did note the complaints in the file. Joshua's continuous beatings were so bad that he suffered traumatic brain injury severe enough to require him to live the rest of his life in an institution for the severely retarded. The Supreme Court majority held, when the suit was brought on behalf of Joshua DeShaney, that the state had no obligation to do anything, and its inaction did not violate Joshua's 14th Amendment right to life and to liberty. The majority declared that even when the state was aware of the abuse and had created an administrative structure to prevent it, there could be no violation. This was because the state had no obligation in the first place to stop a third party's violent attacks, and therefore the department was not liable. To circumvent this precedent, Lenahan argued that the city had violated not her substantive rights, which had been foreclosed by DeShaney, but her procedural rights under the 14th Amendment. She argued that the restraining order constituted a protected property right, a property interest of which she had been deprived. She based that argument on the language of the restraining order, which included a command in all capitalized, very large letters on the restraining order to the police stating, and I quote, "You shall enforce this order even if there is no record of it in the restraining order central registry. You shall take the restrained person to the nearest jail." And I won't quote the rest of it. The Supreme Court majority, however, affirmed the district court's dismissal of her complaint, holding that the restraining order did not create any entitlement to police protection. They also held that the express mandatory language of the restraining order and the arrest law wasn't really mandatory, and that notwithstanding the existence of probable cause, police discretion as a matter of law always trumped a woman's right to rely on the protection that a restraining order was intended to provide. The majority couched its decision in terms of, quote, "the competing duties of an officer or his agency which counsel decisively against enforcement in a particular instance," close quote. But the opinion does not mention, much less analyze or weigh, any single existing or possible competing duty which would counsel decisively against enforcement in Jessica Lenahan's case. What if no conflicting duty clamored for police attention? Dismissing the complaint without analyzing whether there was, in fact, some cause for failing to respond permits officers to place everything, including administrative tasks or doing nothing at all, before protecting a woman from a known threat of violence. Indeed, dismissing the complaint, notwithstanding the allegations of the city's policy of deliberate neglect in domestic abuse cases, makes it hard to imagine under what circumstances a woman could ever rely on a restraining order anymore, even in the many state jurisdictions with mandatory arrest requirements. I don't think it too strong to say that this decision rather adds to their endangerment. Now, I cannot quarrel with the need for police discretion and some deference to it, but discretion, at least in this context, cannot be unfettered. Unfettered discretion, as we have seen over and over again, provides the opportunity for arbitrary and corrupt action. And how far does police unfettered discretion extend? Can arrest warrants be ignored? Can a police officer actually watch a husband beat his wife or child and choose to do nothing because it is a private person inflicting the beating? Seeing Jessica Lenahan's case in terms of the need for police discretion and not in terms of gender discrimination is like the proponents of separate gender military schools who argued in United States versus Virginia Military Academy that single-sex military schools really had nothing to do with gender and everything to do with diversity in educational choices. Well, Justice Ginsburg, writing on behalf of the majority, saw the hollowness of that argument and found that the male-only admission policy of Virginia Military Institute violated the Equal Protection Clause. The court's skepticism of VMI's argument was tied to the volumes of history reflecting, and I quote, a multitude of official action denying rights or opportunities based on sex. Likewise, the history of gender violence and domestic abuse refutes the view that condoning the failure to act in these situations is about the necessity for police discretion. Rather, it is about preserving the historical preference for male authority over women and children and the privacy of the home with the inequality of women and children that lived within it as it was viewed in the last century. It is beyond peradventure that women and children have constituted a class of persons that have historically been, with government approval, at risk of losing life or limb simply because of their intrinsic characteristics. Violence was sanctioned as acceptable domestic chastisement and to be expected by women in order to maintain a male-dominated family structure. Well into the 19th century, the law permitted corporal punishment so long as permanent injury did not result. Take, for example, the North Carolina case of Joyner versus Joyner, wherein the court declared, quote, the law gives the husband power to use such a degree of force as is necessary to make the wife behave herself and know her place. I think I would take a very strong beating. Anyway, close quote. Indeed, violence against women in general, as well as in domestic relationships, has been deemed not only natural, but a male entitlement. And marriage, rather than protecting women from violence, legitimized it. Rape was, and in many places still is, considered a private right, as well as a spoil of war. It wasn't until 1976 that the first state, Nebraska, abolished its marital rape exception. And if rape is not viewed as a right, then it is treated as a crime that can be completely disregarded, as evidenced by the approximately 400,000 rape kits that have not even been opened, let alone processed, and are collecting dust in evidence rooms across the country. Likewise, children were considered chattel, treated as labor, and fathers had absolute control over their lives, including, as in DeShaney, the right to beat them senseless. Even when we moved away from approving physical force, domestic violence continued to be viewed as a natural and, above all, a private event. It was, as one court noted, quote, better to draw the curtain, shut out the public gaze, and leave the parties to forgive and forget, because maintaining the sanctified realm of the family free from government interference was prioritized over trifling violence. This view, although no longer verbalized, is still the underpinning of the failure of police officers, police departments, and governmental entities to protect women and children from domestic violence. And it continues to be, in a subtler and more subliminal form, the underpinning of court decisions that fail to hold these government actors responsible through sanctions, financial or otherwise, for that failure. The narrow view espoused in DeShaney and Castle Rock that there is no right for women and children to be protected by government actors from third-party violence when injury is expected and foreseeable ignores both the history of domestic abuse and the state-created expectation of protection through restraining orders and hotline complaint centers established by the various states. There is simply no difference between removing laws from the books that explicitly permit domestic violence and replacing them with policies of unfettered discretion that in practice permit domestic violence. As I noted earlier, in a given case, there may be reasons, legitimate reasons, for a discretionary lack of response. But when that lack of response follows a history of legally sanctioned discrimination, courts should, on a case-by-case basis, examine and weigh the exercise of that discretion. Without this review in the context of gender violence and domestic abuse, women and children will continue to be treated in the discriminatory fashion that Congress found to exist in this country when it passed the Violence Against Women Act. Now, international courts have responded to the issue of domestic violence much differently than has our Supreme Court. After being denied relief by the United States Supreme Court, Jessica Lenahan pursued her claim in the international arena, petitioning the Inter-American Commission on Human Rights. The Commission is an organ of the Organization of American States, of which the United States is a member. The OAS holds that the rights contained in its initial human rights document, the American Declaration of the Rights and Duties of Man, are binding on all of its members. And the Commission, tasked with safeguarding human rights, investigates petitions of alleged violations by member states. In the Lenahan case, the Commission held that the police officer's inaction violated Jessica Lenahan's and her children's right to be equal before the law without distinction as to sex. The Commission also found the equivalent of a substantive due process violation, holding that the United States had violated Lenahan's and her children's right to life, liberty, and the security of the person, and the children's special right to protection. In addition, the Commission held that the United States violated their right to access judicial remedies. Unlike the majority opinion of our Supreme Court, the Commission rooted its legal analysis in the history and the present realities of domestic violence in the United States. The Commission noted, among other facts, that domestic violence is considered by many law enforcement officers as a private matter and not deserving of protection. The police officers often reinforce traditional patriarchal gender roles, that approximately 50% of the murders in Colorado were committed by a current or former partner, and the victims were disproportionately women, and approximately 45% of the female homicides were committed by an intimate partner. Recognizing the historical discrimination against women, the threat domestic violence poses to the fundamental right to life, and the unique vulnerability of domestic abuse victims, the Commission concluded that gender-based violence is one of the most extreme and pervasive forms of discrimination, severely impairing and nullifying the enforcement of women's rights. This means that states have the obligation to adopt measures necessary to recognize and guarantee the effective equality of all persons before the law. The Commission explained that this obligation requires the state to use due diligence to prevent or respond to gender violence. The Commission concluded that a state violates its obligation when it knows or should know that a woman or her children are facing a real threat of domestic violence, and it fails to take reasonable measures to protect them from that risk. Moreover, if there is such a violation, the victim is entitled to a remedy. The state, even when a private party commits the injury, has a positive duty to remedy the violation by both ending the violating act, punishing the actor, and restoring the victim. The Commission declared that by denying Jessica Lenahan relief and holding that she suffered no constitutional violation, the United States Supreme Court did not fulfill this duty to remedy. Moreover, the Commissioner recognized that this lack of protection was not an isolated occurrence. It noted that in addition to Castle Rock, the Supreme Court's restrictive holdings in DeShaney and United States versus Morrison had severely curtailed, if not eliminated, the remedies available to domestic abuse victims. In Morrison, as you will remember, the Supreme Court held that the civil remedy provided by Congress in the Violence Against Women Act was an unconstitutional exercise of congressional power. The majority asserted that the Commerce Clause gave Congress the power to regulate only economic activities that substantially affect interstate commerce, and that domestic violence is not, quote, in any sense of the phrase, economic activity, close quote. However, logic doesn't explain this result in light of the Supreme Court's prior Commerce Clause decision in Katzenbach versus McClung, which addressed the Civil Rights Act. That case involved Ollie's Barbecue, a small diner in Birmingham, Alabama, that refused to serve black patrons on the premises. The Supreme Court held that the Civil Rights Act extended to private actors to preclude them from racial discrimination. Now, to support the passage of the Civil Rights Act, Congress had collected meaningful but anecdotal evidence and unquantified evidence that racial discrimination negatively affected interstate commerce. However, prior to passing VAWA, Congress spent 4 years meeting with experts and based thereupon concluded that gender violence did impact interstate commerce. Not only that, Congress then looked at reports that calculated the aggregate economic impact through formal studies to quantify that impact. Now, both VAWA and the Civil Rights Act laudably aim to prohibit discrimination by non-state actors who are not themselves directly engaged in interstate commerce. Considering all of the data collected by Congress, however, it is unclear how the Supreme Court could find that the regulation of racial discrimination could be an economic activity when the regulation of gender discrimination is not. Now, it is true that the activity in Ollie's Barbecue occurred between strangers and domestic violence does not, but why this distinction matters is not explained by the Supreme Court. Katzenbach was decided based on the court's concern about race discrimination, but sex discrimination should warrant the same concern. Although certainly different in kind and in degree, both share a history of legally sanctioned or permissive violence. We cannot ignore the inherent vulnerability of women and children to the kind of violence aimed only at them and the history that legitimized it, to which men as a class have never been subjected. No man has ever been considered a chattel owned by his wife and permitted to be beaten into submission. And although both men and women may walk into a dark alley fearing the possibility of robbery, violence, and even death, only women would universally fear the additional violation of a sexual assault. It is also unclear and somewhat ironic how the Supreme Court has recognized this vulnerability and discrimination as a basis for striking down legislation limiting abortion rights, but not as a ground for protecting women from domestic abuse. In Planned Parenthood versus Casey, the Supreme Court took care to explain the uniquely vulnerable position of domestic abuse victims and that special protection and consideration must be afforded to them in the context of an abortion law's spousal notification requirement. Justice O'Connor wrote, quote, "There are millions of women in this country who are victims of regular physical and psychological abuse at the hands of their husbands." I want to say duh, but you don't do that in a speech. Many may have a reasonable fear that notifying their husbands will provoke instances of child abuse and devastating forms of psychological and physical abuse from their husbands, including verbal harassment, threats of future violence, the destruction of possessions, physical confinement to the home, and the withdrawal of substantial support. And the case goes on, quote, close quotes. In contrast, for over a decade, international and foreign courts and bodies have recognized this same disturbing and grave reality as a reason to protect women from gender violence itself. The Constitutional Court of South Africa, for example, pinpointed social patriarchal customs as a cause of sexual assault and better police and judicial protection as a solution. The court said, and I quote, "Often with impunity, men forcibly violate women's bodies, privacy, dignity, and self-worth, freedom, and the right to be treated with equal regard. In short, rape of women and children violates a cluster of interlinked fundamental rights treasured by our Constitution," the South African Constitution. But I say ours as well. "The threat of sexual violence goes to the very core of the subordination of women in society. It entrenches patriarchy as it imperils the freedom and self-determination of women." The court continued, "The state bears the primary responsibility to protect women and children against this prevalent plague of violent crimes, and when courts perform their functions, it is their duty to ensure that their fundamental rights are not made hollow by actual or threatened sexual violence," close quote. Likewise, in the case of Opuz versus Turkey, the European Court of Human Rights explained that Turkey created a climate that was conducive to domestic violence because police officers consider domestic abuse a family matter, with which they cannot interfere, and courts fail to issue necessary injunctions. The court underscored that the state should take preventive measures to protect wives because in domestic violence cases, perpetrators' rights cannot supersede victims' human rights to life and to physical and mental integrity. In other cases, the European Court of Human Rights has reinforced this holding by mandating that a state's duty to uphold human rights includes the duty to act when there is knowledge that a human right is at risk. Similarly, the United Nations Committee on the Elimination of Discrimination Against Women identified Hungary's entrenched traditional stereotypes as a cause of domestic violence, constituting a violence of the equal protection required under the Convention on the Elimination of All Forms of Discrimination Against Women. Now, these cases make clear that inaction is action. As the Seventh Circuit noted in a case before Descheny, it seems incongruous to suggest that liability should turn on the tenuous metaphysical construct which differentiates sins of omission and commission. The majorities in Descheny and Castle Rock constructed such an incongruity, I suggest, which Justice Brennan pointed out as well in his dissent. Inaction can be every bit as abusive of power as action. Today's opinion construes the Due Process Clause to permit a state to displace private sources of protection and then, at the critical moment, to shrug its shoulders and turn away from the harm that it has promised to try to prevent. I cannot agree that our Constitution is indifferent to such indifference. Close quote. Whatever fine line needs to be drawn to prevent unjustified or unreasonable state liability, which I recognize has to be protected, there are certain moments of inaction that are clearly on the wrong side of it. And I believe the cases of Joshua Descheny and Jessica Lenahan fall into that category. The lack of action in those cases reinforces the social tolerance of violence towards women and children, and failing to recognize this inaction as unconstitutional discrimination deprives a class of persons from effective equality before the law. However, as I said earlier, we also need reform on another front, as failing to recognize this discrimination is just part of the problem. The recognition of discrimination without any meaningful sanction when it causes harm ensures its continuation. Thus, we must also examine the exceedingly high barrier to a remedy created by Monell versus Department of Social Services insulation of municipalities from any liability for the actions of their employees. Although Monell held that under Section 1983, a municipality can be held liable when execution of their policy or custom inflicts the injury, it also held that unlike other entities, municipalities cannot be held liable on a respondeat superior theory. As Justice Breyer has noted, this distinction between vicarious liability and the need to establish a custom or policy to support liability is not very readily understandable or easy to apply or susceptible to consistent results. Suffice it to say that the problem involved in proving the existence of an unconstitutional municipal custom or policy are enormous. I could expand on this, but that would take a course, not a lecture, so I'll just say that. Monell, with the very, very broad application of qualified immunity, makes it almost impossible for private individuals to enforce their basic rights under Section 1983 through compensation for their deprivation, and the lack of a sanction creates a culture of inaction. It's not surprising, in light of the highly complex body of interpretive law produced by Monell, that Justice Breyer and 3 other justices have called for a re-examination of that doctrine. And this seems all the more justified in light of the regular news reports of the police violating with impunity the human rights of our most vulnerable citizens. These judicially created walls of immunity should, at least in this context, be reconsidered. In contrast, again, international bodies have focused on ensuring effective remedies for victims of human rights violations and breaking down defenses to government liability, so much so that human rights scholars view the right to an effective remedy as a bedrock principle of contemporary international human rights law. Human rights treaties require remedies for violations, and among international courts, the right to a remedy has been interpreted to mean a right to a full remedy, which includes cessation of the conduct and an award of damages. Now, prompted by both international attention to and our own recognition of the breadth and perniciousness of gender violence and domestic abuse, the necessity to reconsider cases like DeShaney, Castle Rock, Morrison, and Monell will, I hope, be obvious. As our history recognizes, we have a continuing duty to reconsider and redirect our jurisprudence when it is necessary to ensure that the ideals upon which our existence was originally based are realized in fact. Our history graphically illustrates that providing equal protection and justice for all requires both diligent and continuing efforts. As Justice Brennan noted, and I quote again, "The genius of the Constitution rests not in any static meaning that it might have had in a world that is dead and gone, but in the adaptability of its great principles to cope with current problems and current needs." Close quote. And Justice Kennedy echoed the same thought beautifully in this year's historic decision recognizing the pervasive discrimination that had denied the LGBTQ community their constitutional rights to equal protection, privacy, dignity, and liberty. He said, "The nature of injustice is that we may not always see it in our own times. The generations that wrote and ratified the Bill of Rights and the 14th Amendment did not presume to know the extent of freedom in all of its dimensions, and so they entrusted to future generations a charter protecting the rights of all persons to enjoy liberty as we learn its meaning. When new insight reveals discord between the Constitution's central protections and a received legal stricture, a claim to liberty must be addressed," close quote. And complying with this admonition is not new, is not radical, is not unprecedented. In fact, it is the norm, not the exception. Adjustments to our jurisprudence have been made throughout our entire history. We have always worked to eliminate constitutional contradictions and diminish the gap between our avowed foundational principles and the actual protections which our government was formed to secure. For example, after declaring as a foundational principle and at the same time after declaring equality as a foundational principle, and at the same time failing to recognize that blacks and women were likewise entitled to equal treatment, we worked to remedy the inconsistency. We all know the progression of our jurisprudence from slavery to Plessy versus Ferguson to Brown versus Board of Education. Likewise, we have seen the progression of women's rights after the passage of the 19th Amendment in 1920, which assured women the right to vote. Although another course should examine why our courts did not recognize that the 14th Amendment on its face already gave women as citizens of the United States the privilege of voting. Thereafter, however, our jurisprudence over time declared that it was illegal to pay women less than men for exactly the same work, to treat women unequally in regard to jury service, to discriminate in employment and in schools on the basis of sex, and to deny women the right to control their own property. And in yet another context, judicial perceptions of the death penalty have not been static over the decades, although much more reform is certainly needed. The Supreme Court uprooted prior precedent to hold that it was cruel and unusual punishment to apply the death penalty to minors in Roper versus Simmons and to execute the mentally retarded in Atkins versus Virginia. So whenever the scales of cultural and historical prejudices fall further from our eyes and we perceive yet another previously unacknowledged corner of inequality and injustice, I believe we have to examine it anew or again to ensure that legal protections exist that conform to the great principles we espouse. And I suggest that the lack of protection for women and children from domestic violence is such an unacknowledged corner, and that our courts have taken a wrong turn in failing to give meaning to our avowed right to life and liberty. I reiterate Justice Blackmun's call to align our jurisprudence with the constitutional principles upon which it is based. As he stated in his dissent in DeShaney, and I quote, "It is a sad commentary upon American life and constitutional principles, so full of late of patriotic fervor and proud proclamations about liberty and justice for all, that this child, Joshua DeShaney, now is assigned to live out the remainder of his life profoundly retarded. Joshua and his mother, as petitioners here, deserve, but now are denied by this court, the opportunity to have the facts of their case considered in the light of the constitutional protections that 42 U.S.C. Section 1983 is meant to provide. Domestic violence victims are constitutionally entitled to protection in the United States under both substantive due process, and which protects fundamental personal rights and liberties, as well as the Equal Protection Clause. I cannot see that there is any greater liberty interest than the right to live one's life without being maimed or raped or beaten. Nobody can disagree with that statement. Our courts need to consider the reasoning of our international judicial colleagues in recognizing that domestic violence is a violation of our human and constitutional rights, and the victims of it are entitled to a remedy when a violation occurs. It cannot be that the richest, most powerful, biggest nation in the world has no mechanism to protect human rights. Thank you very much for listening.
Judge Barquette, thank you. That is a spectacular addition to the tradition of the Madison Lecture, and I think really quite a rousing call to action. These are painful cases to think about, and you've put them in a context that really does require us to think again about the doctrines that were formed around them and about notable disjunction between the way these issues are treated within the United States and abroad. No one is better situated to offer that than you, so thank you again. You are all invited to join us for a reception here, but I hope you'll join me in thanking one last time Judge Barquette for giving us